So now we've had these two strong statements, and we can have a question. And right in front is Pankaj Mishra, who I will call upon.
Thank you very much for this extremely stimulating discussion. And as actually while both of you were speaking, I was thinking of a case, a very famous one, that seems to illuminate both sort of sides of the question, which is the satanic verses controversy in India, which is where it originally began, as many of you would know, where the government banned the importation, as it put it, of the novel into India in 1988. And this action was taken while the book had already been imported. It was widely available. Anyone could read it, really. Anyone could access it. I had a copy. But the government thought that it needed to do that in order to basically maintain what Professor Waldron called a kind of social peace, and was supported by a lot of liberal intellectuals in the country, including atheistic Marxist intellectuals. And this has been done actually several times before, where the government has indulged in a kind of symbolic politics, where the book is, or the cultural artifact is widely available, accessible, and yet it wants to basically deploy some of these, actually what Professor Appia called multiculturalist strategies, where the politics of recognition come into play, where the dignity of community belonging, or the sense of that certain community which feels itself under siege politically, and indeed physically. I must tell you the context of this action by the government, which is that right-wing Hindu nationalism in India had just begun to emerge very, very strongly and had become a really menacing force just around that time. And I should bring my own personal circumstances into this, because I was in Banaras, living there soon after, just before the banning of the book. There had been serious riots, Hindu-Muslim riots, and as often happens in Hindu-Muslim riots, the police had gone completely berserk and killed a lot of Muslims. So the Muslims were definitely perceived by a lot of liberals in the town as people on the defensive. So this action of banning the importation of the book was seen as a kind of an act of appeasement of a very wounded minority. So my question really is there a pragmatic middle ground between the affirmation of the principle of free speech and the deployment of multiculturalist strategies, where the book is available, anyone who wants to read it can read it, and yet the government can somehow improvise a policy which also addresses the sense of offense. I mean, obviously, this still opens the question as to how do you construe offense, and who does the construing, and how is a work of art to be defined as hate speech, and who does that defining. But I just want to open up this question using this particular example.
Do you want to go first? I think that this draws the question right up in the foreground of the distinction between preventing violence, just policing to save people's lives. I had the same feeling about the publication of the Danish cartoons, the republication of the cartoons. I think we have to make a distinction between two motives for taking action of the kind you described. The first would be that people ought to be protected from other people reading this. As I said, I think that's very much the wrong motive. That doesn't mean an end of policing. If the publication of a book is going predictably to lead to violence, then you protect people by taking whatever. Now, I think you should take whatever steps you can, if possible, short of censorship. In the case of the Danish cartoons, for example, I think it would have been outrageous if the government, say, of the United States had prohibited their publication. I think it is cowardly of the Yale University Press at this stage of the proceedings, but to self-censor. But when they were first published, I was actually supportive of the private decision, not government imposition, but private decision to have an eye to consequences. And so I was supportive of the decision not to republish the cartoons. And I may have taken, in the circumstance that you describe, I may have had the same view about the satanic verses.
Can I just say a word? I do think that the special circumstances of a country where there is a history of widespread intercommunal violence do make a difference to how social peace is pursued. I don't want to comment on the satanic verses controversy itself, but I know that India maintains quite strict laws regulating the conduct of elections, and that candidates who have secured votes on the basis of religious antipathy or appeals to religious denunciations can forfeit the seats that they gain. Our colleague Zakharov talked about that once in the colloquium at NYU. And I think there are a number of ways in which one can adjust all sorts of laws, not just speech laws, but electoral laws, all sorts of aspects of our democracy to reflect this. I will say something else about the suggestion that there might be moderate in-betweens. The best drafted hate speech laws are drafted in a way that identifies certain safe havens for expressions of certain kinds. Some of them refer to scientific or academic contexts. That's not much help to somebody who is an embittered, poor individual who wants to express them. Many of them are festooned with adverbs, so that if your speech can be shown to not be threatening or abusive in the tone and manner of its publication, then the prosecution cannot be sustained. And thirdly, and this does go, I think, to an issue, maybe the first of the issues that Ronnie raised about the European laws, most of these laws do identify places where you may speak in private, where you had reason to believe nobody would, but your immediate interlocutor would overhear you. Conversations in restaurants, conversations in one's home. So there are a variety of ways in which you attempt to provide means whereby similar sentiments can be expressed in ways that are not as directly damaging to the social environment.
Melis. Melis Bevan.
Yes, I have a question for Jeremy Waldron, which is that if you do have certain restrictions on hate speech for the reasons you've very clearly explained, is there any mechanism for implementing them in the context of new media? Because it seems to me that what we've been talking about, particularly recently, is the question of publication. I wrote a blog, which some people might have seen, on the cartoons controversy. And in researching that, it took me approximately 15 seconds to access the cartoons that had been banned on the internet. The same goes for a variety of hate speech and stuff which can be very, very easily accessed, and there seems to be no mechanism for preventing that.
I agree that's a problem, particularly when there is a disparity in the legal regimes as between perhaps the most powerful country in terms of internet proliferation, the United States, and say the European countries that in a sense share the internet with the United States, but the internet itself can, to a certain extent, escape regulation. There can be a move down to the lowest common denominator. Now, we have found ways of dealing with that, with ordinary defamation. We have found ways of dealing with that with scourges like child pornography, where there is an ability to track down internet postings to their source and to track down those who access these materials. The same enthusiasm has not characterized hate speech, but I know that a number of people have discussed the difficulty that arises when the medium in which the speech is expressed is a worldwide medium, but the laws are uneven and different from country to country. There are also other issues about implementation that are worth mentioning. In many countries, the specific consent of the Attorney General is required, or some other high law officer is required before there can be prosecutions. These prosecutions are not under the jurisdiction of local officials, for example. And Canada has, I think, disgraced itself by allowing local race relations committees, in particular small towns, to initiate prosecutions in various ways without these safeguards of bending over backwards to only identify the most egregious cases. So I think there's a wide variety of implementation strategies and issues. By and large, prosecutions tend to be sporadic and rare under these laws. That doesn't mean that the laws do no good. The laws have an important expressive function. Ronnie asked the question, what evidence do we have that these laws do any good at all? And he acknowledged very hard to generate the counterfactuals, because we can't just compare Belgium with the United States. We have to compare Belgium without the laws with Belgium with the laws. But one example that is worth considering is the laws relating to racial abuse in football grounds and during football matches. I know that a number of football players in Britain found it very disconcerting to move from an environment in Great Britain where football clubs can be fined when their supporters are chanting racist abuse at black players, to move recently to Ukraine in circumstances where such racist abuse is tolerated, if not encouraged. I don't say this explains the recent defeat at the hands of the Italians, but...
I just have just one point. You make the analogy with child pornography. But there seems to be a problem there, because people are prosecuted for accessing child pornography, not just for initiating it. And the rationale for that is partly that in order to create images of child pornography, you actually have to commit assaults on children. In the case of hate speech, are you really suggesting that we would be going down the road where accessing hate speech could be criminalized? Because that seems to me to be opening a Pandora's box, which would be completely impossible to control.
Yes, you're quite right that there is that structural disanalogy. I mentioned child pornography among a range of other exceptions to the free speech principle to indicate that we should be flexible and open in our thinking about different structures of limitation and different structures of enforcement. So the way we think about fighting words, the way we think about child pornography, the way we think about such offenses as of sedition, as we still have, they're all different. And the idea was not to think of any very strict analogy between them all, but to try to open up our sense of how disparate the relevant exceptions might be.
Now, Ronnie, may comment.
Well, one problem with new media is that anonymity is extremely easy to secure. And again, I don't think, given the difficulty in finding out where a blog originates from, I don't think that criminalizing is going to have much effect if you permit the reception of the internet, which can be unsigned or which can be signed with false names. And indeed, much of the most hateful hate speech in the world is unsigned and anonymous. One of the reasons that people give for the decline, the relative decline of hate crime in the United States is that the law provides no reason for people not to identify themselves as threats, whereas in Europe, people are encouraged not to identify themselves.
Tim Gart-Nash had a question.
Yeah, forgive me if this very question was put while I was unavoidably out of the room for a few minutes, but I wanted to take Ronnie Dworkin's third point and turn it into my question to Jeremy, which is, and Jeremy and I have talked about this many times, what would you say is the best example of a country that has effectively used hate speech laws, taken in the round, in the manner you describe, to achieve a better ordered society and to protect the dignity and social standing of vulnerable minorities? Because that, it seems to me, is your claim in the round, not any particular piece of legislation, but that over a period of time. And I hope you're not going to say Britain, because it certainly doesn't hold up. For example, if I may just add, the legislation on incitement to religious hatred, which you mentioned, has actually been totally emasculated by the English pen clause that you cited, which was drafted by the famous free speech lawyer Anthony Lester, because it's very, very hard to imagine any significant prosecutions given that huge exception. The incitement to racial hatred is inconsistent with the other hate speech laws, appeared first in a very different context, namely one in which there were actual threats of violence to people of immigrant origin, notably Pakistanis, but again has, in my view, been quite ineffective. But what would be, to put it positively, what would be your best example of the best case?
Well, I will rise to the provocation and talk about the English case because it's one that I know. I wanted to contest a number of the points that you made. You said that the Lester Amendment has emasculated, curious word, emasculated the religious hatred provision. I could give you an example right now of a form of religious hatred speech that would be prosecutable that clearly doesn't fall under the Lester provision, which would be that all Muslims, men, women, and children, by virtue of their faith, are committed to jihadist and criminal terrorism. Now, that would be a statement which is directed at the individuals, which is not merely an aspersion on the Quran or the religion or the Prophet themselves, but is a particular attack on what I'm calling the dignity or the social standing by defaming individuals. And to suggest that that, as it were, that gets the benefit of the Lester Amendment, I think betrays a misunderstanding at best of what the Lester Amendment involves. I do believe that it's part of the life of any decent piece of legislation, during its drafting, during its consideration, and during its amendment and so on, to develop different doctrines and to see how they fit in the life of the various hatred provisions. The racial hatred provisions, which date back, I think, to the 1960s, the religious hatred provisions that accompanied the abolition of the offence of blasphemy in Britain, they all have involved complicated drafting, sometimes hesitant, sometimes ambivalent, doing what legislators do best, which is to make their best, to give their best account of what's needed in society at the moment. Now, I think in the wake of power-light hostility towards immigrants and to the people of Afro-Caribbean descent, particularly in England in the 1960s, the provisions on racial hatred played a significant part in preventing more widespread outbreaks of such racist violence as there was. You asked the question as though there were some sort of timeless competition. Is it New Zealand? Is it Belgium? And so on. I'll give you another example, and it's an example that doesn't exactly enter the sort of the National Football League that you want me to participate in. But in almost every large business in the United States, there are workplace rules which have a quasi-legal status so far as employees are concerned, which insist that employees may not publish, paste up posters, send around emails among the employees denigrating the humanity or defaming people as criminals or as animals of their fellow workers. Those who run businesses know that it's impossible to engage in the serious pursuit of business and industry in a large enterprise without such rules. Most universities have such rules. And what we have failed to do, I think, in our thinking about broader society is to wonder whether there are any lessons to be learned from the success of that. So that is a success story, that most businesses now do operate on the basis of reasonable religious, racial civility among their employees. I mentioned the football example, which I think would be a third example in Great Britain. I believe that these laws have had a massive effect in changing the culture of the football not terrorists.
Hooligans.
Hooligan.
Terraces. I was...
speech against football support.
Indeed, that's right. So, I don't know, Tim, I could say New Zealand or Belgium or whatever, but I believe in every one of the cases that I have mentioned, the hate speech measures, along with other measures, because it's never an either or, along with other measures like more speech, responsive public education, and so on, these have played their part as one measure among others in reducing and making it easier to enforce laws against discrimination and violence.
But how do you know? We say we feel that the workplace laws have been effective in the larger community, but we have no reason to believe that. The hate speech laws within universities and within workplaces are justified precisely on the ground that they don't usurp the ability of people, of anybody, to express those views publicly as part of the political process.
Yes. No, I wasn't putting these forward as an answer to Professor Dworkin's argument about legitimacy, but simply an answer to this provocation, given account of the success of these laws without mentioning Britain, I think was the question.
In the back. There's the man in the back. What?
There are a lot of
All right.
people all over.
We'll go over it. We'll do it next.
This time.
Lars Gule, Oslo, and Akershus University College of Applied Sciences. A remark on offense versus violation, because I don't think anyone can have a right not to be offended. If someone says all atheists are idiots, they're free to say so. And you can say the same about Muslims and Christians. But you cannot say the same thing about blacks, women, gays. There is an important difference in what you can change and what you cannot change. About your opinions, which you're entitled to, but you are not entitled to not have your opinions offended. You have a right not to have your human dignity, color of your skin, your sex, sexual orientation, is part of your humanity. Human rights are defending this human dignity, and for that reason, you cannot suspend human rights and say that, well, they don't count. You cannot use human rights to violate human rights. I mean, that goes without saying, but it's also stated in the human rights that you cannot use them to violate someone's rights.
Yeah.
And this is what happens if you say you can suspend human rights in order for someone to have a say that, well, I would like to test how it would be without human rights. We need to suspend them so that my point of view is heard. I think Professor Dworkin is overstating his case somewhat here. Thank you.
Thank you. I don't think that one has a human right not to be offended. And that's the heart, it seems to me, of the protection of freedom of speech. It's the heart of democracy. You do have a human right to be allowed to express your opinion, but you do not have a human right that no one express an opinion contrary to yours. Now, you make a very important distinction between what you can change and what you can't change. In the case for, how would you adjudicate the case of the second statement, the hateful statement that I made? I didn't say people from a Muslim background have these terrible characteristics and opinion. I said people who are devout in the Muslim faith, who accept it. In the case of gays and lesbians, the argument now all over the world, but we're focused now on Britain, about gay marriage is exactly about whether the characteristics that follow from having this perhaps innate sexual orientation are such that certain kinds of penalties should attach to them. Now, the distinction between the basis on which claims are made about your group, between those that you can change and those that you can't change, is completely fragile. It's illusory. Because what is argued, say in the United States, racial profiling, what is argued is that there are connections between what you can't change and behavior. And it's always hinted that these are genetic, that is, you can't help them. But nevertheless, social policy, it's argued, should attend to them. That is the basis of the argument.
We have a question from the gentleman on the left.
Thanks. You were focusing if the law is making the progress or not, effectiveness or not. This is not the point. If you think about killing, still it's going on, and there is quite a law against killing.
Against?
Killing.
Killing.
The very point is what kind of society do we wish to achieve? And this is completely different. I am wondering if you were speaking in the same way if you were black and Muslim. It seemed to me that your attitude is just playing for the sake of freedom for maybe 10 in the words. You don't get the point that minority are part of this kind of speech. You don't get the point that your way, saying you can read this book or not, is used by hurting people. It seems to me that it's very, very important, not what we achieve, but what we wish to achieve.
Well,
and we have a different point of view.
there is, of course, a question about what kind of society we want to achieve. I say we want to achieve a fair democratic society. That's the kind of society I want. If you say to me, you can't have that and also have a decent society where people respect each other as citizens, even though they disagree, I don't see the evidence for that. It seems to me yesterday's description about successive generations and the changes made is more optimistic than you say. But I do think that it's more important to protect people from economic discrimination, discrimination in housing, discrimination in professional opportunity. That's first and foremost what's important. And we have to develop a sense of the kind of society we live in, which allows us to do that consistently with our principles.